Yes, Madam Chair, and thank you and members of the committee. And although TTLA is against the bill, with that said, we are grateful and thank Chairman Murr for inviting TTLA and other stakeholders to be part of the process to address our concerns, with the understanding and full disclosure that TTLA can never be for a bill that infringes upon the freedom of Texans to elect their judges. As we have gone through this process and even during the interim hearings, we have questioned the workaround to this appointment being constitutional. And I heard today that officers of the state can be appointed 2 years in a row. I'm happy to continue the conversation because when I read TLR's foundation manual about judicial selection in Texas, they admit that all Texas judges ultimately stand for election. So I look forward to continuing that. The other aspect of our concerns that we have expressed to Chairman Murr has to do with the broad jurisdiction of the bill. And if the intent and the purpose is to truly create a business court, TTLA is willing to work with the committee to narrowly tailor that because the jurisdiction, again, is pretty broad. Some of the issues and concerns that we brought up have to do with, for example, a governmental entity, let's say a state agency, can unilaterally do a power sweep and invoke jurisdiction without consent of the opposing party. And that lives in section 003. The motion to remove or a business being allowed to just from the outset file a if we're going to talk about unpredictability, if we're going to talk about increasing costs, every motion to remove could potentially have a motion to remand, which could potentially lead to appeals if this bill is not narrowly tailored to capture truly business court issues. For example, UIM claims involve declaratory judgments many times, and DEC actions are within the jurisdiction of a business court. And so uninsured motorist cases are also a part of, could be a personal injury case. And if they end up, not all lawyers are going to read this statute the same. If it becomes one, not all judges are going to interpret it. And so cases could be removed, and even with the threat of sanctions, again, that's inviting more litigation. That is increasing the cost to keep cases out of the business court that truly do not belong there. So unless we specifically exclude cases like UIM, like Insurance Code 541 and 542, which we have talked about, then I see that judicial efficiency and judicial economy would not be met moving forward. So I see that my time is up. I do have some other concerns, but I'm willing to continue working with Chairman Murr and the committee to allow Texans to either have the option or the choice to move into a business court, or at least narrowly tailor it so that many of our cases don't land there.
Chairman Murr.
First, thank you. For all those, my door has always been open to anyone that's interested in talking about the bill, both solo practitioners and stakeholder groups. And so we have met numerous times, and I'm confident that we will continue our dialogue. You said you had a couple of other topics that were of concern to you. I would like to hear them, if you don't mind sharing.
Absolutely. Well, a couple of them are, again, the overbreadth of the jurisdiction. Every contract claim that's $10 million could land in this court. Now I think it's been expanded in the substitute as commercial transactions, which isn't, again, completely defined. And one of the major concerns as well is the section on remote proceedings and remote jury trials. And TTLA has always stated its position that we are opposed to mandatory remote jury trials. We know that the Texas Supreme Court has amended the Texas Rules of Civil Procedure after weigh-in by many stakeholders. And the bill as written does not track the language of 21D. So with 21D, a mandatory remote jury or a remote jury trial could be tried by consent of the parties. This language allows for there to be good cause shown, and a court could order a remote jury trial. So that is just one example of some of the concerns, and I'm happy to continue the conversation once committee is over.
Thank you for sharing those. I appreciate it.
I had a couple questions. I want to kind of walk through and go through, we've talked a lot about the election of judges.
Right.
We've kind of fleshed that out. But I want to talk and kind of spend a little bit more time talking about the jurisdiction of the bill as a whole and some of the concerns that you raise about that. Because to me, this seems like very broad as well in terms of especially what we've already highlighted, just an open-ended threshold of monetary damage. But walk through, if you would, some of the other jurisdictional issues that you see with the bill. And I'm curious more about the declaratory judgment aspects of personal injury practice. We frequently have to sue insurance companies for DEC actions. How do you reconcile that inconsistency in this?
Sure. So I want to be, again, full disclosure, there was some language in the bill that stated for similar purposes, which is the big hole that you could drive a truck through, and that was removed. So that was helpful. But then the issues pertaining to insurance code and uninsured motorists, where there could be a case that involves a DEC action that could be in excess of $10 million. And if that is severed, or even if it remains together with a personal injury case, could be removed to the business court. And then at that point, any kind of, for example, unfair settlement practices, which lives in the insurance code, it would be individual versus insurance company, or it could be a business versus their own insurance company, a first-party insurance case for property damage, a construction defect for a commercial business, having their commercial building not constructed to code, for example. All of those could end up living in this business court. So if the purpose was to be a rocket docket, it could end up being clogged docket. And that is one of our main concerns.
Is one of the concerns also just the nature of the parties? A lot of folks have talked about businesses need a place to resolve business disputes, but what happens when one of the parties isn't a business? You're just a single person.
Well, and that's why I think we have discussed talking, at least if we could leave it to business on business versus individual versus business. And I know there's a debate on both sides, but we also had the opportunity to discuss alternatives with Chairman Murr about business on business within the existing court structure. And we're willing to continue visiting on those alternatives.
And what are your thoughts on the removal process? Do you have any opinions on whether or not it would improve the system if it was by consent of both parties versus one party unilaterally being able to access this?
Right, and it does remind me of federal court quite a bit, but again, when we're talking about the governmental entity, that's just a unilateral where they can invoke jurisdiction as a concern. I know that it says the judge shall remand, but again, there has to be some litigation to get there. There is also a new provision within the committee sub that where a judge can, upon its own, his or her own order, move the case into business court.
And that would be without the consent of either party.
That is correct. And there's not a clear mechanism of, other than a motion to remand back to that trial court judge, how to deal with that aspect of it. So there's a number of concerns, but I'm hopeful that we can work through it. Even if the portion of the elected judges is not fixed, at least TTLA can serve as a resource.
Thank you. Members, any other questions?
Thank you.
Okay. Chair call.